Good afternoon, everyone. My name is Magali Diaz, and I'm the Education Director at the Down Syndrome Association of South Texas. We are based out of San Antonio, and we provide services and supports to individuals with Down syndrome, all ages from birth until adulthood, and their families by providing resources, support groups, and a lot of social events. And today we are here with some of my friends and colleagues. So thank you for having us, both Alison Packard and Alison Schauberg.
Thank you for having us. Yeah, it's kind of like homecoming. The three of us all sat on a task force, if you will, with the Texas Partners in Policy Making. So it's nice to be back with each of you today. So thank you for joining everyone today. We are going from 12 to 1, so we'll be finished by 1 o'clock if you're planning. Today's meeting is being recorded, and you will get a copy of today's slides, so you don't have to take notes on everything. If you've attended before, welcome back. We're glad you're here. And our format typically is to go ahead as the meeting is going on and put your questions in the chat box. We're going to answer as many questions as we can. I'm going to read those out to Alison and answer just as many as we can. Consolidated Planning Group is a holistic special needs financial planning firm. We bring a lot of webinars all across the state of Texas for families with loved ones that have a disability. And our webinars are really designed. My hope, my heart is that they kind of equip you with the tools and the resources that you need to be a super advocate for your loved one and to feel empowered that it is not as difficult as it is. But in truth, navigating everything as it relates to our loved ones with a disability, it is difficult. It is frustrating, mind-numbing, time-consuming. There's a lot of other words that we can continue to we could move on, but we want to help you with that. So we're super excited to be here with you today. Again, Alison Packard with the Packard Law Firm in San Antonio, and today what we are talking about today is guardianship and alternatives to guardianship. And that's kind of a big, it's a big buzzword in our community, and it's something that you haven't had to think about for a long time. You've got a little one, but before, we blink, they're 18 or they're coming around the bend and turning 18. It seems like, oh no, the days are long, but the years go by quick. And our parents probably told us that, and we thought, whatever. But then here we are. So anyway, having said that, it's just a pleasure to have you back with us, Alison, and I'm going to turn everything over to you.
Thank you, Alison, and thank you, Magali. It's a pleasure for me to be here. And it's funny you say before you know it, they're 18. I have a daughter who is, in fact, I need to update my slide because she's now 28. So before you blink, they're 28 too. So it is an interesting world, and it's, when we have kids with special needs, it can be challenging, but I don't think there's any joy quite like it. It's just a unique type of parenting opportunity, and I'm really grateful for my daughter. She is certainly my motivation to get into this area of practice, so it's a pleasure to talk to you. Of course, I always am supposed to tell everyone whatever I tell you is not supposed to be construed as legal advice for your particular situation. You should always consult with an attorney. We're just doing education, blah blah blah. That's my little spiel. Okay, so when we have children with special needs and they get to adulthood, it's a time to really think about what the right option is as far as moving forward. As you know, when someone turns 18, a parent's authority to make decisions for that child really ceases. They can't automatically make medical decisions or sign the educational decisions, go to the ARD meetings and sign the IEPs without, in some cases we can continue that, but it's time to really think, how do we want to make sure that authority continues? You have a few options. One option is just to let your adult child represent themselves, and that works in some cases. Another option is to have a guardianship, and that's sort of an extreme on the other end, where your child will have their rights removed and you as a guardian will take over those responsibilities. And then, as Alison mentioned, there's a lot of in between. Those are less restrictive alternatives from the guardianship. And so there's not one way that works best for everyone. This is going to be very unique to your family. What is best for my daughter may not be best for your son. And so we're all on a different spectrum, and it's a big decision. So let's kind of go through the choices. First of all,
Allison, can I just want to ask something? Can you talk about I think that there's something in the Texas code, and I'm paraphrasing, like least restrictive, most appropriate. And then that's one thing I want you to comment about. But the other thing is a lot of parents just don't know, and we're really encouraging and educating parents that they don't have to know. They just have to know how to get in touch with a professional on this, because you guys are really designed to kind of walk through all of these options and help determine what is best. So when a parent doesn't exactly know, sometimes it's a slam dunk, but it's not always a slam dunk. So can you talk about those two things before we kind of get into all of this?
Sure. Yeah, you're exactly right. There was some guardianship reform done in Texas a few years ago. And one of the changes was that before we have a guardianship officially taken care of in a court, before a guardian's appointed, we have to have considered alternatives to that guardianship and looked at less restrictive alternatives than the guardianship. We're going to get into this, but when you're under a guardianship, you lose a lot of rights. So we always want to make sure there's not another less restrictive alternative. And so the way we do that, we would, if you were to come into my office, we would talk about whether or not your child could sign a power of attorney, supported decision-making agreements, different things. A lot of times we can avoid a guardianship of the estate, and we'll get into details of that but we can avoid that typically by having a parent appointed as a representative payee to manage Social Security funds and having a special needs trust. It's not just what you decide with the lawyer. You should talk to your doctor. So your doctor is going to need to fill out a form and state on there what the doctor thinks. And so you should be familiar with that form and talk to the doctor and work together to decide what is the least restrictive option for my child. And then besides the doctor giving his or her input, in many courts, there's a court investigator who will also look into whether or not the least restrictive alternative is happening here. And of course, before guardianship is finished, there's an attorney ad litem appointed to represent your child to also, again, give their opinion as to whether or not this is the least restrictive alternative. So there's several checkpoints along the way to make sure guardians are not appointed without serious consideration of other options. Did that answer your question?
Yes, but is there a general, talk to us about, I know that there's not always a line in the sand, but a general opinion, and I guess is to each his own as far as the, professional counsel. But as far as incapacity, is there an IQ score, or is there is there a line? Is there a line in the sand that it would be construed that maybe a person wouldn't understand what they're signing when signing a POA?
There's not an absolute line, but if you look at the determination of an intellectual disability at an IQ of 70 or below, that is a good, starting point. Now, there are exceptions to that rule. There are people with, an IQ below that, maybe just borderline, that may be able to understand a power of attorney. And then there are some people who have an IQ above that need guardianships. And so it's not a set line, but I would say if you're looking at someone with an intellectual disability, it might be that that's going to be difficult for that person to understand a power of attorney to be able to sign that document. You can't sign a power of attorney if you don't understand what you're reading. So I would say if somebody's got a very low IQ, you pretty much are not going to find another alternative to the guardianship. But again, it's a very individual case, and sometimes people with a little higher IQs do need guardianship. So we look at all the facts and put them together. It looks like Allison's pulled up on the screen, the certificate of medical examination. We call that a CME for short. And this is the doctor's form that I was referring to earlier. This has to be filled out by a physician licensed in Texas, if we're filing the guardianship in Texas, and this physician needs to indicate what their opinion is as to what the proposed ward is the person who's going to be under a guardianship. It's not a great flattering term, but that's what we're still using in the courts. So the doctor will say, this is what I think the proposed ward can and can't do. And if you can see it on your screen on question number 5, the doctor's going to indicate whether or not the proposed ward could vote, make decisions about marriage, choose where they live. And so based on those answers, that will help me as an attorney craft the guardianship application. Now, I don't have to follow this exactly, but it is very, very strong evidence. So typically, if parents don't agree with what the doctor said, I ask them to go back and get the doctor to support what they want, because it's going to cause problems otherwise. But that doctor will tell us whether or not this is going to be a full guardianship where all of those rights are removed, or a partial or limited guardianship. It is possible to have a guardianship where someone couldn't retain the right to vote, for example, maybe even try to drive. They're not super common, but it is possible. I did notice, I'm not going to monitor this chat very well, but I did happen to notice that one, where we can find the form. It is, I think it's on the Bexar County Court. My email address is at the end of this presentation, and you'll get a copy. If you want to email me, I can send it to you. No matter which attorney you have help you with the guardianship, you're going to have the same form. So it should be out there on the internet or on the Bexar County websites, but if you can't find it, I'm happy to forward it to you.
Alison, I think, you and I have talked about this before, and we've seen more and more physicians being reluctant to sign off on this. I know you're not a physician, but can you address this? Have you seen this? And what do they do? What do they do when their longtime PCP doesn't want to sign off on this, or, just go somewhere else, go see a specialist, go to the psychiatrist, the psychologist, and is this a trend, or what's happening with that?
I think there's not going to be a set answer for everyone. The first thing I would say is, if your doctor doesn't want to sign off on this, why is that? To really talk to your doctor. Is it because they don't think a guardianship is necessary? If they don't think it is, then you should listen. If you think, oh, this doctor is wrong, then yes, you can go to another doctor. It needs to be completed by a physician licensed to practice in Texas, but it could be a primary care doctor, a specialist such as a neurologist, a psychiatrist, not a psychologist, but another specialist. Needs to be an MD or a DO. Why are they doing, you want to have that good conversation with your doctor and talk about the fact that you are aware of less restrictive alternatives, and explain why those alternatives won't work. A lot of times, just speaking to the doctor and explaining the concern, if you have a story of someone trying to take advantage of your child, sometimes the doctors will get on board that way. But otherwise, you could see another doctor if you needed to, but I would listen to the doctor. If they have concerns about your child being under a guardianship, it's worth listening and seeing why that's happening. It just depends on the doctor, depends on the situation. All right, I'll keep going unless you want to tell me I've got another question. Okay, so I do want to make sure we're clear. There is guardianship of the person in Texas and guardianship of the estate. Guardianship of the person, that is going to give you as a guardian the right to make medical decisions for your adult child under guardianship, the right to sign contracts to decide where your child is going to live, whether it's with you in a group home. It will let you pretty much handle everything other than money. Guardianship of the estate is what the type of guardianship you need if you want to have court authority to handle money. Now, a lot of times we can avoid a guardianship of the estate, and a lot of times that's a great idea, because if we have a guardianship of the estate, you have to, in most counties, have an attorney file an accounting for you every single year. So this is an expensive process, but guardianship of the estate is going to be continued legal fees on a yearly basis. So we always look to see, do we need a guardian of the estate? And a lot of times we can avoid that one with less restrictive alternatives. As I mentioned, for many of our kids who might be receiving SSI or SSDI, even though our children can't handle money, we can become representative payees and handle all those Social Security funds. And so if that's the only source of income for your child who's under a guardianship, then it might be you can manage it through the representative payee system with Social Security. It's a good idea for all of us as parents to consider having a special needs trust created so that when we die, we leave assets to that special needs trust. Again, if there's a trustee in place, we don't need a guardian of the estate because we already have somebody managing that money for our child as trustee.
We have two good questions. In general, and I'll just ask the question because this one always comes up, if we're trying to plan financially, what is the range, kind of a price range in general? And I know there's a lot of attorneys out there and you don't set their prices, but for a non-contested guardianship, what should people plan to spend? And is a partial or limited guardianship about the same price as a full guardianship, or is it less?
No, a partial guardianship, to my knowledge, I don't know anyone who would charge less. It actually makes it more complicated, not less. So it will, at least what my experience has been, I just charge the same thing. I imagine most lawyers would do the same. When you get your guardianship letters, it might make your letters a little more expensive. In Bexar County, where I live, letters of guardianship are $2 a letter. That's your certificate that you're a guardian. If you have a limited guardianship, it might be $10 a letter because we need to attach the court order with the details of the guardianship limits. So, about the same though, not any price difference that should sway what you do or don't do. That shouldn't be a factor. The cost, I would say most areas in Texas, you're going to be looking at least $4,000 to get it done. Typically, you're going to get attorney's fees anywhere from $2,500 would be the very low end. And I've seen them up to $4,000 or $5,000 for attorneys to do for their fees. But on top of the attorney's fees, the filing costs are very high, typically $500-$600 to file it. You're going to have to pay for an attorney ad litem, which is another attorney. And also you need to be bonded to be a guardian in Texas. There are a few counties where you just sign a personal bond or a small cash bond, but in most counties, in my area at least, the courts here ask for a corporate bond, which costs typically $100 a year renewed, or a one-time fee of $375. Now I'm in San Antonio, so I'm talking Comel, Guadalupe, sort of this area. I'm not sure if the courts further away might handle the bond differently. But I mean, Allison, I don't know if you have any other thoughts, but I would say plan at least $4,000 and up to get it all done.
I think that's a good range. I just want to mention, because we have people that attend this from all over the state. Galveston County. Now you have to live in Galveston County. You can't just go there. There's two counties, and I'm not sure of the other one, and I don't know if it's out near you anywhere, but Galveston County does free guardianship, and you don't have to be indigent. They have a program, they have like an endowment, and it's free. So if anybody is here from Galveston County, you should know that. And there's one other county, if anybody knows, go ahead and put that in the chat box. But again, you have to live in that particular county. The other question is if we move within the state or out of state, what do we have to do? So if we already have guardianship in place, does it transfer easily? Do we have to change counties? What happens?
You do have to change counties. You do have to move the guardianship. Before I go back to that, I don't want to forget to make one comment. Let me go back to the fees, because you reminded me that I should say this. If you are very, very low income, there are programs in most counties where you can get it done cheaper. So I'm not aware of any county in my area that will do it for free if you have plenty of income, but if you are below the poverty line, for sure there are going to be programs that will help you do that. And let me just make one quick plug for the Morgan's Wonderland Multi-Assistance Center that's going to be opening in October in the San Antonio area, and they will serve everyone across the state. They are going to have a program where you'll be assigned a navigator for your child, and they'll help you figure out if there's some kind of resource for you to get this guardianship done very inexpensively. We're really blessed in this area. We're going to have our probate court judges actually going to the MAC, this center, to do the guardianship hearings, and we're going to have a great volunteer program. So if you're in this area, look into the MAC. It doesn't open until October, but that's going to be another great resource for people with, you know, family members with special needs that need to consider guardianship. Okay, let me go back to, okay, so transferring a guardianship. Yes, the guardianship is tied to the county where you live. So if you are transferring to another local county, it's pretty easy, but you do have to go to court. And I'll give you an example. If I have someone coming from Comal County, just across the county line into Bexar County, well, in Comal County, that judge might let them just sign a personal bond. In Bexar County, we're very strict. You have to have that corporate bond. And so we would have a real quick hearing and the judge would make sure we get the bond in compliance with our county. But you don't have to revisit whether or not a guardianship is needed. The incapacity is established for life unless you go back and present evidence that there should be a change. So you're really just making sure that you're in compliance with that county. If you come from another state, again, we don't have to revisit the incapacity, but it might be a little more to get you into compliance. So did that answer that question? Okay, let's see. Let me look on these slides. So the guardianship reform in Texas, that is what I was alluding to earlier, and Allison asked me about, to make sure we don't have a less restrictive alternative, to make sure that we are considering alternatives to the guardianship and supports and services. And in fact, in every guardianship application, I have to include a comment about what the alternatives are we considered. And when I go to the court hearing, I have to ask my clients, did you consider alternatives? What are the supports and services? So this is really important to think about. And let's get into some of those. For guardianship of the person, some of the less restrictive alternatives we can consider are, as I mentioned, a partial guardianship, a guardianship with limited authority. So maybe this person needs a guardianship, but they really want to keep their right to vote. Well, let's let them keep their right to vote if that's important. And that's happened many times with some of my clients. But more common, we would look at the powers of attorney. Can this person, if it's your child, do they have the ability to understand a medical power of attorney and sign it? Could they read a durable power of attorney? We have statutory durable powers of attorney that are a little bit complicated, but we also can do a simplified durable power of attorney. Now, this is not something where you can just take a document and stick it in front of your child and say, sign this. We can all do that with our kids, but they need to understand what it is they're signing. And if they've got a very low IQ, then arguably, if you have them sign that, you're looking for potential problems down the road, because it might be you have it signed in front of a notary, but then down the road when you really need to use it, someone could challenge the capacity. If you use an attorney, that will give you some backup as far as, the attorneys, we can't do these unless we feel confident that this person has capacity and knows what they're signing. So that would be a push. If you have a child with a borderline capacity, maybe it's worth spending a little money and get it done in a lawyer's office. But otherwise, you can find these powers of attorney on the internet, and lots of organizations have them. Another quick plug for the MAC at Morgan's Wonderland. We're going to have clinics where we do these for free for people who have enough capacity to sign them. Another less restrictive alternative to think about are supported decision-making agreements. That is a much simpler document to understand. There's also a declaration for mental health treatment. And Allison, if you could advance the slide, I think we've got kind of oh, that's medical power. We'll get to it. I'm going to elaborate on supported decision-making agreements in a minute, but let me just say medical power of attorney. This is just reminding me to tell you that medical power of attorney does not kick in Texas until the doctor says you have no capacity. So since I think I'm talking to a lot of parents, it's important to understand that medical power of attorney doesn't mean you just automatically make medical decisions for your child. If your child signed a medical power of attorney, you are saying my child has capacity to understand these things. And so it might be that the doctor still listens to your child because they're the ones who signed it. They're the ones capable of making their own decisions. It's the guardianship that would give you the authority to take over and make the medical decisions. Durable power of attorney, that one can be effective immediately when your child signs it. But again, all of these documents, we've got to make sure that the person signing them understands them. And we also need to appreciate the fact that if someone has the ability to sign these documents, they have the ability to revoke them. So in other words, if I have my daughter appoint me as her power of attorney agent, and next year she wants to say, nope, mom, I now want it to be my boyfriend, then I'm going to have a hard time arguing that she had the ability to choose me, but she doesn't have the ability to choose the next person. So that's something to consider. Alison, if you'll go to the supported decision-making agreement. And as we just move from this durable power of attorney slide, we just noticed that one, I think I mentioned it, it can be effective immediately or only when a doctor says you're incapacitated. You have an option on that one.
I just want to chime in right here, and I do this every time because I think it's really, really important. Whether you have a loved one with a disability or you have neurotypical kids that are going to college, these are good documents to have. The power of attorney, the healthcare power of attorney, it's super important. I always mention that. We've had families that had kids at the apartment fire at Texas State. We've had families that have had neurotypical kids have mental health crisis where they went to a facility and they wouldn't even tell them where they were. So these are things that are important. And furthermore, it's important to have intentional conversations with your aging parents or any aging loved ones in your life about these documents. Don't wait for the crisis to happen and realize that they're not in place. So these are easy to get and put in place. And I just think about you and your spouse, your other kids, and other people that you love, because it's something that kind of gets put off, on the shelf of I'm going to do it later, and then the crisis happens.
Excellent point. I agree 100%. So that's a great point. Okay, I don't want to spend too long on this because I do want to have a chance to really get into the guardianship, but we mentioned the supported decision-making agreement as an alternative to a guardianship. This is a really common philosophy, kind of a modern way of thinking, and I hear it all the time, I don't need a guardianship, I'm going to use an SDMA, a supported decision-making agreement. It's important to understand that this is a document that is much easier for our kids to understand. And I'm sorry to just say kids, adult children now, but the supported decision-making agreement does not give you as the supporter the right to take over and make decisions. And we've got to understand that. So if my daughter signs a supported decision-making agreement and makes me her supporter, that means I can go to her appointments, I can help her communicate with the doctor, I can help explain things, I can give her my counsel, but she is still the one making the decisions. And so I personally do not recommend relying only on a supported decision-making agreement. I think it's risky. If that's your only document you have, it might help you with school, IEP or ARD meetings. It might help with other situations, but you probably would want a power of attorney to back it up. And so if you can't get those two together, I would kind of look at maybe the guardianship being an option. If you go to the next slide, Alison, I think I've got
and because sometimes we have people that are attending our webinars that are from out of state. The supported decision-making agreement is a Texas thing. Some other states have them, but not all states do. So if you're attending from out of state and you don't know what this is, it might just be that they don't do that in your state.
Excellent point. Excellent point. Okay. Let's keep going. I don't know if I had a slide showing, but it's a real simple document. Oh, there you go. This is just kind of a sample. You can see how easy it is for someone to understand what they're signing. This is going to be a lot easier than a power of attorney. But again, personally, I think if you're relying only on a supported decision-making agreement, that may not be enough if your adult child needs some help down the road. So, but it is effective in some situations. And I like the philosophy that we're trying to let our adult children keep as many rights as possible and give them the chance to try to make decisions. We all need to practice. We all were 18, 19 at one point, and a little practice making our own decisions is good for all of us. And sometimes with that practice, people can get better. Okay. Let's keep going. A guardian of the estate, I already mentioned this. We can usually avoid a guardianship of the estate if we're talking about someone who's developmentally disabled and now reaching the age of adulthood. And we can typically avoid that by either these powers of attorney we've been talking about, maybe with or without a supported decision-making agreement added, becoming a representative payee with Social Security, and also, and this is a whole nother webinar that Alison covers a lot, but special needs trusts. You know, if you don't know about special needs trusts, go look into that, because that is a key way of avoiding a guardianship of the estate and protecting government benefits. Okay. Do you want to go to the next slide, Alison?
Yes, we had a quick question. Can you please confirm if we can have more than one supporter named in the supported decision-making agreement, or is it only one? It's a great question. I haven't heard that one before.
It is a really good question, and I will tell you the law is it's not clear. And so I don't know the answer. I have heard both answers. And if you call me later, I'll tell you what I do, but I don't want to put it on a recording. I would say talk to your doctor, but for sure you can have one. I do think it doesn't make sense if you have multiple supporters. Then maybe the argument from the medical community's perspective would be, you know, the doctor would say, who am I supposed to listen to? You know, who is it that's supposed to be here? And so there are a lot of people that say, no, you can only have one supporter. Other people see that differently. And honestly, it's not clear. You'll hear it both ways. So that's a great question. Here's a slide just talking about representative payee. It's easy to do. This is not a document that you need to do with a lawyer. You work it out with the Social Security Administration. You can actually say who you want to be your own representative payee if you lose capacity in later years. There's ways to do that, but it's easy to get someone appointed as a representative payee as you work with the Social Security Administration. And also, let me add this, Social Security does not take powers of attorney. They will take your guardianship and they will talk to you, but representative payee is sort of like their system for power of attorney. So going in there and saying, hey, I have power of attorney for my daughter, they say that's nice. That's not what we take. So important to understand that. I
just wanted to add also, there is a form, it's called Form SSA 3288. 3288. So for anybody that they don't have guardianship, they're not going to have any form of guardianship. They've got a power of attorney, and the Social Security Administration doesn't take the power of attorney. So I fall in this category with my kids. You can have them sign that 3288 form, and then that will allow you to call on their behalf. And you do need that form, so you can download it just from the web. SSA 3288, and get that sent in, and then they'll talk to you. They won't give you a hard time anymore. That can make that all go away.
That's a great tip, Alison. Thanks. Yeah, that's great. Okay, trustee, again, there's a lot we could go into detail on this, but you know, a trustee, basically what a trust is you have somebody managing property as the trustee. They're in charge of managing the fund. They actually legally hold title to the funds, but they're doing it for the benefit of someone else. Now, there are trusts where I could be my own trustee, but in other words, I could be my own trustee for a trust for my benefit is what I'm trying to say. But special needs trusts are the type of trust we're typically looking at for families like mine and probably most of yours on this call. And that special needs trust, you're always going to have one person acting as a trustee for the benefit of the person with disabilities. They cannot be their own trustee. That person is not a guardian, but it avoids the guardian of the estate, like we said. But it's important to understand that if you have a special needs trust in place, your trustee has no authority to make medical decisions, to decide where your child lives, or, you know, for that matter, to open up a bank account other than managing those specific trust funds. So the trustee is limited to the powers that the trust document gives them and whatever property is held in that trust.
I just want to ask a quick question, because there's always questions about this. So like for successor, are there issues with a successor guardian? Not everybody has endless family to be a successor guardian, or maybe it's a family friend or something like that. Do you take issue with a successor being a guardian and a trustee? Is there anything anybody should think about that, or how that could be an issue or not?
Yeah, you know, people come down on both sides of the arguments here. Some people will say, if my child has a guardian, I don't want them to have too much power, have easy access to the money. I want them to go to a trustee to get help to ask for permission to use the money. Other people say, well, if this person's going to be the guardian, let them be the trustee as well, because it'll make it simple and they'll be able to easily access the money. I will say on these trusts, we could have a whole long conversation about this, but choosing the trustee is really, really important. And if I could just, go off a little bit here, the most common problems I see are families like mine where, mom and dad create a trust and sibling is the trustee. And we run into all kinds of problems when siblings just borrow money from the trust because they know mom and dad would want them to borrow that money to get a new car that is needed or something. I mean, there are so many problems that go wrong. So when you do your special needs trust, when I work with families, that is a real serious conversation we have about who the right person is to serve as trustee. It's not going to be the same for every family. That's where we get into really specifics with your family dynamic.
And I just want to be clear that being a trustee is not necessarily a small job, depending on what is owned in the trust. If there's properties owned in the trust and there's other things owned within that trust, it's not really a small job. And somebody with a financial background, somebody that's has a nuance for that, is probably wise. And of course, there are professional trustees like banks and stuff, Cadence Banks, Texas Bank. There are several special needs divisions within some of those banks that are managing. They'll be a professional trustee. And I believe that when we're talking about trusts that have, $1 million or more dollars, if we have millions of dollars in a trust, you may really want to consider a professional trustee. But an attorney will talk to you about what those options are, and you may have somebody wonderful in your family that, you may have a banker, you may have multiple people in your family that could take on that job, but you got to just choose wisely. That's all there is to it.
Yeah, I agree with that. And let me just add one other thing while we're on this topic. If you do go with a professional trustee, a bank or something, there are things we can do to add trust protectors, trust advisors, where family members can stay involved and have a lot of power, but not necessarily take on the full responsibility of the trust.
I'm a real fan of the trust protector in the example of things are going awry and we're dipping into stuff that shouldn't be happening and things like that. So I'm definitely a fan of that. We did have another question, and it says, do you suggest that the trustee be compensated for their efforts? Usually most states have a law about the compensation, about the max compensation that can be paid. But is there a rule of thumb for compensation for trustees?
I think a trustee should have the right to accept the compensation. If it's going to be a family member, a lot of times that family member will waive that right and not take the compensation. But, yes, I do think in all cases, you probably should allow that trustee to have the right to be compensated. It is a big job to manage this trust.
Is there a rule on that in Texas for as far as gross receipts or gross revenues, or a percentage or anything like that? Or is it just kind of vague in Texas?
Well, it depends. If in the guardianship world, if you are a guardian of the estate, there's very strict rules on what proper compensation would be for a guardian of the estate, and happens to be 5% of all the money that you're bringing in and paying out. And so a lot of courts are used to seeing that 5 in, 5 out rule, and they will use that as a starting point. But it really is going to depend on what the trustee is doing. Are they selling a house? Are they having to clean out a house? Are they, what is their role? And so the judges are always going to listen to the individual circumstances. I've heard people say that judges tend not to like trustee fees to be over a certain dollar amount. I've heard $100 an hour, but that's going to really depend on your particular judge. So again, guardians of the estate, management trust, court managed trust, there are going to be some strict rules, but a trust that you just create, it's going to be a little more open as to the compensation.
We've got another question, and it's a good one, and it comes up a lot. What if my kid's already 18? I don't have the power of attorney. I don't have the supported decision-making agreement. Can I still get it? What if my kid's 26 and I probably should have got guardianship a long time ago? Can I still file for guardianship? Talk to them about that.
Yeah, great question. No age limit. And you would be surprised how many very elderly people I work with, you know, they might come into my office in their late 80s, you know, and say, oh, we haven't done this. So there's no limit. If you haven't done it yet, you still would look at your options and treat it the same way as, you know, look at this. And honestly, if your child's older, you probably have a better feel for what they can and can't do and which options will work. But yeah, no limit. You can get a guardianship. In fact, most guardianships are for elderly people. So it doesn't have to be done right when a child turns 18. Okay. I know we want to go back to the guardianship. This is just a slide about how special needs trusts are different from other trusts. It is important, if you're going to do the special needs trust, to use an attorney who understands special needs trusts. You've got to make sure there's certain language in that trust. If you go to an attorney that just uses a typical trust as a template, you may not have the appropriate language. The person who with disabilities can't have any control. You've got to have some stated purpose on how this trust is meant to supplement and not supplant government benefits. There's certain language we need in there about income. And if all of that is done properly, then the trust is not a countable resource for government benefits. If the language is not done correctly, and if the trust is not administered correctly, then it's going to be accountable resource. So my example of, you know, the sibling who says, hey, I'm just going to borrow money from the trust so we can go on vacation or buy this car, that just turned that trust into a countable resource. Because when you have a special needs trust, the funds, the property can only be used for the person with disabilities.
I just want to reiterate that. I can't stress that enough, because we see this every week where documents that either it's a DIY, we've copied something from the internet, or my neighbor or my brother's an attorney, albeit a real estate attorney. But anyway, where, you know, again, they're educated, they went to law school, they're smart, but they're not nuanced and special needs. So I just really believe that, because really what ends up happening, so you save money on a DIY, or you save money because your neighbor did it for free or something like that, some attorney that you know. But you end up spending the same money because a professional that's what they do ends up fixing your documents, and you end up paying for it. So I just really suggest, and we're happy. We're not attorneys. We're on the financial side. We always talk about the difference between a special needs planner, financial planner, and a special needs attorney. And we're the money. They're the legal documents, and you really got to have both. But we do have, you know, relationships all across the state. So wherever you're at, if you need a solid referral for somebody that we know is good, their fees are reasonable, and you need help, someone you can trust, certainly reach out. We're happy to make a referral. And then also the elder law. What is the website for that, Allison? Because I know that they can put in their zip code and pull up people that way as well.
NAELA, the National Academy of Elder Law Attorneys, NAELA, NAELA. And then also there are some other organizations such as Academy of Special Needs Planners, and you know, you can find an attorney through some referral sources like that. And I want to get back to the guardianship. It's hard not to talk a lot about this because it's so important, and we could talk for more than an hour easily just on these trusts. But there's one more slide that's coming up, and this is something to make sure you understand that there are two types of special needs trusts. One type has a Medicaid payback on it, which means when the beneficiary dies, Medicaid takes the remaining funds, and the other type does not have a Medicaid payback. Sometimes we have no choice. We have to use the Medicaid payback. And typically when we have to use that, it's because estate planning wasn't done before the parent died. So I just say this because that's another reason you want to make sure you don't just go to any old attorney who might pull up a template and create some first party trust with a Medicaid payback when it wasn't necessary. We see that a lot. So anyway, I just want to throw that out. And I agree with, you know, Allison's got all kinds of videos, and you are welcome to call my office if you need more information on trusts. Okay, but let's get back to the guardianship. So I'm just going to go through these slides unless you interrupt me with some questions, Allison. So how long does the guardianship process take? That is going to be county specific, but I would say plan at least a couple of months. Typically, we're seeing 3 or 4 months in my area of Texas. Occasionally, we can get it done in under a month, but that's the exception. So I would allow at least a couple months, maybe in your head plan about 4 months. Okay. Temporary guardianship That is available in emergency situations. So occasionally we have something come up where it really is a true emergency and we do a temporary guardianship. But this is a guardianship where you can get that done within a couple of weeks, but you still have to go back and get the permanent guardianship. It's only going to last for 60 days. And to get a temporary guardianship, it has to be a true emergency. I'll give you an example of someone I worked with recently. Child was in the hospital, turned 18 while in the hospital with COVID, on a ventilator, needed some medical decisions made, turned 18. We had to do an emergency guardianship to get that, get mom and dad appointed as guardians very quickly. And then we had to go back and get the permanent guardianship. So a lot of times these temporary guardianships are used with elderly people who might have somebody abusing a power of attorney, stealing their money, putting, parents' life in risk or their health in serious jeopardy, or taking their money. So I wouldn't depend on a temporary guardianship, but it is an option in emergency situations.
We saw one last year where a grandma got temporary guardianship of 4 minor grandchildren because the parents were killed in a car accident. And that's really the only one that we've seen. I mean, we don't, obviously, we refer out for that, but we definitely saw that as well. And I just wanted to, we hear all the time, and I think you mentioned this, that you don't have to, but you can begin the guardianship process 6 months prior to the child turning 18. And beginning that process, like, we hear that all the time. What does that even mean? Like, I can begin the process. What does that mean?
Yeah, the great question. Well, you can actually file the application in the court. So let me talk about this because it is important on the timing. So that doctor's form, the physician CME, on that form, the doctor is going to state when he or she examined the person who's going to be under a guardianship. So it says, I last examined the proposed ward on such and such a date. Whatever date the doctor writes there, we need to get the guardianship application on file within 120 days of that date. Okay. And so there are some exceptions for intellectual disability, but I would just rely on that 120 days. It's a good general rule. So that means that if I want a guardianship of my daughter, I can go drop off the form, but if my doctor hasn't seen her in the last couple months, it's not going to work to have the doctor fill out the form and say, oh, I saw Angela last, 6 months ago, 7 months ago, because it's too late for me to use that form. So we've got to get that date straight, get the application filed within 120 days, but we can file that up to 6 months before a child turns 18. And I do that a lot. And what we end up doing is we just wait for the court hearing until the child is 18. At the court hearing, the judge is going to find that that child is now an incapacitated adult. So they have to be an adult to make that finding. So we end up a lot of times getting everything finished and just waiting until the 18th birthday. And then we go to court and get it, get the actual guardianship appointment. Does that make sense? So as far as getting started, you can go to the doctor anytime, just don't go too soon because you have to be within that 120 days of, getting it filed, if that makes sense. So so if you wanted to file at 17 and a half, I suppose you could go see the doctor, 2 or 3 months before 17 and a half, but don't do it too early. Did that answer that question?
It did. And I just want to bring up something that does come up a lot with this topic of, like, what about divorce situations? What about when we have one parent that is against this and one parent that is for, or one, I mean, I know there's a such thing as contested guardianship, but what if guardianship really does need to happen and we've got somebody against it? Does that matter? Or what if the parent, there's an absent parent, maybe out of the state, out of country, there's been no contact?
Yeah, great questions. And yes, it matters and it makes a difference. So even if you have another parent who's been out of the picture for years, maybe they owe a bunch of money in child support, don't want to be found, we have to try to find them. There are, if we can't find them, we have to show the court that we tried, what we did. Maybe we hired a private investigator. We had someone do what we call a skip trace. A lot of times the court staff will help me look for absent parents. And then if we just can't find them, we can get substitute notice through publishing something in a paper. But even absent parents, if you're a biological parent, you're going to have to be involved in this guardianship process. Same thing with siblings. They can sign waivers or they can be served notice, but we can't move forward with the hearing until the appropriate family members are notified. As far as divorce goes, you know, you can have co-guardians. So sometimes we have divorced couples serving as co-guardians even though they're divorced. Other times we have divorce situation where one parent will be a co-guardian with a step parent. And a lot of times if there's a divorce situation, maybe just the biological parent will serve as sole guardian and not bring in a step parent just to avoid some complications. But you know, if you have one parent who is just fighting against this, saying a guardianship is not necessary, most likely the judge is going to order us to go to mediation, to get a mediator involved, to try to work things out. And if we can't work it out, we go to court, and it can be a contested guardianship hearing where we let the judge decide, you know, and that can get extremely expensive. And so, you know, if litigation is expensive. So anytime you have fighting going on, whether it's, you know, some other issue or a guardianship issue, it can get expensive with depositions and all kinds of testimony and witnesses, and it also drags it out. So it's certainly not the fun type of guardianship. When I have a situation where people are at odds, I usually try to explain the process and have them kind of work it out beforehand. If you have a divorce decree that has lifetime child support already entered into the divorce decree. In other words, if there's already a court that is managing this child's, you know, their child support and possession and custody, it is also more complicated. So that's going to be, we're going to have to talk about that to see how a guardianship would play in, or if it's something where you're going to rely on your previous court order. Typically what we do is we take a divorce decree or some standing court order in a family court, and we can consolidate it into the probate court so that one judge is making all the decisions about the guardianship and the child support. I know we're going off the weeds a bit.
I have a quick question on the joint managing conservators. So let's say there's divorced parents that are joint managing conservators. Can they act alone, or do they have to act in tandem? So I guess what I mean by that is, can dad make a decision to sign something? Like, as far as like a requirement of both parents signing, would they both have to sign something, or would one or the other be sufficient?
So if you're talking about if they became co-guardians, typically what I will have in my co-guardianship order is that one parent can act. But, you know, if the judge felt differently, then there could be specifics into the court order as to how the co-guardians are going to interact. But usually it is common with co-guardians to allow just one guardian to be able to act independently of the other guardian.
Okay, and then the other question is basically, can you give a highlight one more time of what physicians can sign the CME? And then the other question was, is if the kid just got an annual physical, is that sufficient, or is there some other kind of special exam that has to happen for the CME?
So there's no special exam as long as your doctor knows the child, or, you know, your adult child well enough to fill out the form. So, you know, if they have the information they need, they can base it off of a prior exam, as long as it wasn't so far back that it's not current enough to file with the court. Remember, you know, we need that exam to take place within 120 days of filing the application. Now there is, I will tell you, if it's based only on intellectual disability, sometimes we can get around that. There's a couple years of, anyway, but I don't like to rely on that. It causes problems. So as far as the type of doctor goes, it is any doctor who is licensed in Texas. And I say that because I'm in a military city, and a lot of times we have military doctors that don't have Texas licenses. So as long as the doctor has a license to practice in Texas, they can sign it. It could be a pediatrician that knows your child well. It could be a family practitioner. It could be a neurologist, a psychiatrist, a neurosurgeon for that matter. You know, it could be any type of specialist who felt like they knew your child well enough to fill out that form. What you don't want to use is a nurse practitioner, a psychologist, you know, a physician's assistant. Now, if that's who you typically see, the physician's assistant could fill it out and have the doctor sign off, but you can't rely only on those other specialties. Okay, For someone to serve as guardian, this is important to understand. You have to have a pretty clean criminal history. If you have felony convictions, then even though you're mom or dad, it's going to be a problem. Anyway, we'll just leave it at that. What's going to happen is when you file for the guardianship, we're going to fill out some paperwork, and you're going to have a criminal background check done on you, done on a co-guardian. And if there's criminal history, it will come up and the judge will want to know about it. Now, sometimes we have someone who has, a drunk driving charge from 20 years ago, or some other thing from, back when they were 19 or 20, and the judges will work with us on that. But if it's something like abuse of a child, if it's something like child pornography, something where the judge is going to be concerned for obvious reasons, you may not be appointed as a guardian, even though you're a parent. So come clean with your attorney about your criminal history so you can discuss that at the outset. And typically we can work with it unless it's something pretty severe. Otherwise, the judge is going to always allow preference to the closest family members. So if mom and dad are around, they're going to get first rights to be the guardian. And so if sibling wants to be the guardian instead of mom and dad are going to need to be involved and either say, yes, we support the sibling being the guardian, or no, we don't. And then the sibling would have a right to go to the judge and say, well, let me tell you why I'm a better choice and all these other problems. But there is an order of who should be the guardian. And, if there's no family available, then the court will appoint someone who's best qualified, even if it's a non-relative. And, sometimes we need to do that.
A couple of things on the guardianship. We have talked about this before in our college planning programs. A lot of people have kids that are going to go on to higher education and other programs. You need to check with those programs specifically on whether or not they'll take somebody who has guardianship, because some of them will not. So I just wanted to mention that. And then the other thing that we've seen over the last, few months is where, choose wisely, obviously, successor guardians. But it might not be like, for instance, I have wonderful parents. They're great, but they're aging, right? So you may have wonderful parents too. So if you die, the first thing that comes to mind is my parents, but they're not going to live forever. So they could have more than one guardian that passed prior to them turning 18. So just thinking about some of those things, because some of those guardianship choices, and of course you can change it over the years, but thinking about what are the challenges, for your loved one, as far as being a caregiver. As a caregiver, could you do it if you're 85? Could you do it, could you handle it if you were 27? So when you're thinking about siblings or things like that, I think those are all important considerations, and it changes with time.
And can I just add one comment? We talked about the judge is going to look at an order, but if you have an order, meaning the order of family, who should be the next guardian. But if you have a will that specifies who you think should be the guardian, the judge is going to give that a lot of weight. It doesn't have to follow that. Of course, if your child, say you appoint a sibling and that sibling has a criminal history, judge isn't going to appoint them as guardian. But it's important, if you have a guardianship, to do your estate planning, to fill out those documents, to let the judge know who you want to become the guardian when you can no longer do it.
We got about 5 minutes left, maybe 4 minutes left. So I want to make sure that you hit on any of the key points that you definitely don't want to miss.
The only thing I would say is, that I don't want to forget to say is, I'm thinking of a bunch of things. Okay, one, if you get a guardianship, it's not one and done. If you've got to report to the court every year, even if it's a guardianship of the person, you won't need a lawyer to do an accounting, but even guardianship of the person, you need to file an annual report. If you don't do that, you could be out of compliance. I once heard someone say, I don't need the guardianship anymore, I'm not going to file the report. That doesn't work that way. What that means is you could be disqualified as the guardian and someone else could be appointed, or some agency in your county. So be careful about that. Once you have a guardianship, you have a guardianship. If you need to modify the rights of the guardianship, say your adult child has surprised you and now they can do all kinds of things you didn't think they'd ever do, you can go back to the court and restore rights. It's basically the same process in reverse. You're going to need a doctor to say, fill out that CME and say, yes, now they can do this, they can do that, and you can go to court and do that. And then the last things I would say, this is a tough decision for a lot of us. I'm with you as a parent. For those of us who have kids with disabilities who are pretty high functioning, it is a tough decision. You are welcome to call me and I can talk it through with you, talk to other people who have guardianships. But if you feel like this is a hard decision, you're not alone. It is for a lot of us. But if you have questions about this, feel free to call my office. You're going to have that on the slides, and I'm happy to talk to you. Oh, as you
Just
pull up
kind of
that
go
last,
through.
yeah,
Yeah.
as you pull up that last slide, the annual report, that is what will give you a renewed guardianship letter. So when you become a guardian, there is an expiration date on that letter. So if you fail to file that report, your guardianship letters expire. And the judges a lot of times will let you get back in compliance, but if you do that too many times, they might say you're not the right guardian. So if you're a guardian, look at your expiration date of the letters, make sure you file your reports and keep your guardianship current. When you're renewing your guardianship, it's typically $10 to file that report and a couple dollars for each letter. So less than $20 and you're good to go. And I think that's good.
Yeah, I think this is really good. And I've heard a lot of families say that it is kind of an emotional process. It is a big deal. And some, families truly don't want to take, rights away. And then I also hear from a lot of families that at 18, our kids aren't there yet. We're hopeful and optimistic that they're going to get there, but at age 18, they're not there. So thank you for, giving that, example of that they can get their rights back. So if they're not there yet and they arrive later, that they can still, get all of their rights back. And it's good. And I think it comes down to safety, right? The best interest of the individual, safety. There's so many concerns. And it is a big deal and emotional. So for all of you that are thinking about it and going through it, we know that it's a big deal, and we're definitely glad that you're here. I did run into a case in the last couple of weeks that there was an issue, and it was an example of a family. So parents had an adult daughter with a disability who's in her 40s and who had a child herself who was turning 18 and with intellectual disabilities, and there should have been guardianship in place, but there never has been. But it was determined that they couldn't sign a power of attorney or have capacity to understand the power of attorney. And this family was getting to the point of saying, "Oh my gosh, what happens now? Hey, we're getting older. There is nobody else. And what happens? There's no guardianship in place. There's no successor guardian. If something happens to my husband and I, they're both going to become wards of the state." And so they're kind of in the process of kind of getting that all moving. So anybody that, says, okay, well, I didn't do it when I was 18, or I didn't know, I didn't have this information, that, there are fixes to things, and there's people that can answer your questions. So I'm definitely glad you're here. Alison, you're always awesome, and we love partnering with you. You give a lot of great information. Alison is in the San Antonio area. She works with a lot of counties across the state of Texas. Give us the handful of counties that you work for guardianship, but I know that you can represent people as far as the special needs trust, first party, third party, pretty much across the state. But tell us about the counties for guardianship that you have worked in.
Yeah, thanks. For guardianship, we will cover most counties. I've gone all the way down to Hidalgo, certainly go up north of Austin, but it will be more expensive. So what, I do a lot in Bexar County, Comal County, Guadalupe, Kendall, kind of this area, Medina. We do those routinely. We have done many guardianships up north of Austin and north of there. And like I said, Hidalgo, Uvalde, but I charge a higher fee for that, especially if I have to travel. Let's all hope that we can keep doing Zoom court hearings. That keeps the cost down. So depending where you are, I could represent you in kind of this general area within a couple hours, but I make exceptions, but it costs more money. So I usually say, look and see if there's someone local that will be cheaper.
And again, we're happy to refer if somebody, in your area, if it's not, anywhere close. Well, I think we're out of time for today. Thank you. for partnering with us again, Magali, and we're happy to be here with you, and we hope to partner with you again soon. Thanks everybody for your time. You can check out our YouTube channel. I know Alison mentioned it. We've got a lot of webinars out there on basically all of these topics that you could possibly imagine. There is a big webinar coming up on Monday with Andy Hardwick with the Social Security Administration. He's been with the Social Security Administration for 40 years. He's retiring. And so that last webinar is on Monday from 12 to 1. So if you've got questions, he's got answers. Make a point to hear that webinar on Monday. Thanks so much, everyone. It's certainly been a pleasure, and I look forward to connecting with you again soon.
Thanks, everyone.
Thank you, everyone, for your time. Bye.